So I'm Martha Minow, still the dean here, and it's just a great personal delight as well as professional delight for me to welcome to campus two distinguished alums who happen to have a close and very productive professional relationship. This is part of the series that we have launched here that brings together Boss and Counsel to have conversations between clients and their lawyers. Here we have the very special relationship between inside counsel and outside counsel, and one of the questions is, who is the boss? And I'm going to be really interested to hear more about that.
There's only one answer to that question.
So Lesley Rosenthal is really a dear friend as well as an outstanding lawyer. She was recognized as the, what's the title? Outstanding General Counsel of the Year? Pretty cool stuff. And in her work as the Senior Vice President, General Counsel, and Secretary of the Lincoln Center for the Performing Arts, she is like the lawyer for a city-state. She runs everything. It's employment, it's real estate, it's, you know, envisioning what the future of the arts should be in New York, and New York is the capital of the world. So there we are. Under her leadership, there really have been some tremendous changes and wonderful developments, and you'll hear about them. Peter Britell, also wonderful alum, is at the distinguished firm of Venable, where he is in a constant kind of conversation and communication with Lesley as well as other clients, and his work ranges across real estate, many other business kinds of transactions. I just want to name some of them because they're so impressive. He has advised the Lower Manhattan Development Corporation on the construction and real estate issues in the World Trade Center redevelopment project, just as an example. And I'm going to shut up because you want to hear from them. Thank you for being here.
Thank you so much, Dean. What a pleasure it is to be back. And under your great leadership, the school is really thriving. What a fantastic turnout. Thank you all for coming. We wanted to talk to you a little bit today about a view on the attorney-client relationship that I personally really never had the opportunity to give a lot of thought to or hear from people about when I was here 25 years ago. I view my job as in-house counsel as much more closely aligned with the rest of senior management. So I'm part of a very tight-knit team that includes the chief executive officer, the chief financial officer, the chief administrative officer, the chief operating officer, and then people who handle fundraising, program planning, marketing, and public relations, and so forth. So while I always have my lawyer hat on, I also need to make sure that all of the legal judgments and decisions that I'm making are going to help propel the institution forward in the direction of its strategic plan, in fulfillment of its mission, in the direction that's been set up by our board of directors. It's a little different of a vantage point on legal practice than when I was outside at a law firm for 13 years before that. And I think what you'll see here are some illustrative examples of the view from in-house, the view from outside, and how that relationship can work.
Also, I would comment that rather than discuss general principles of how outside counsel relates to a client, and in this particular case, an extraordinary client, we will use the slides as illustrations, and I think you'll get a sense of the kinds of things that we do. I note, by the way, that some things haven't changed. This room filled up from the back first to the front. We're not going to call on anybody.
All right.
So these are the topics which we are going to discuss, all in the context of a $1.2 billion redevelopment of the entire Lincoln Center campus, which spanned 10 years. And as we go through, we will highlight some of the topics and some of the issues that were involved. But I suggest that as you see the slides, and particularly when you see the amazing pictures that you're about to see, you as lawyers think about the dozens of agreements and the hundreds of legal issues that had to be solved and completed in order to achieve what Lesley's about to show you. Go ahead.
Great. So Lincoln Center is a 501c3 not-for-profit organization whose mission is to bring the best art to the greatest possible number. That really just in a nutshell. We have a 75-member board. Our physical facilities were built between 1959 and 1969. And as we got closer to the turn of this current century, people were realizing that the facilities were coming up on 50 years old. They were starting to age. They needed both infrastructural repair, but also the expectations of artists and modern audiences were really changing. And another thing was changing too, and that was society around us. Originally, Lincoln Center's architecture was kind of a citadel on a hill. It was the arts literally raised up above street level with a whole lot of travertine marble, very opaque, that maybe purposely, maybe not so purposely, sent out some very elitist keep out kind of messages. And our board in more recent years realized that the arts are really part of the fabric of the community, and that if the community isn't taking part in the arts, and if we are not projecting ourselves out into the community, we're not doing our job. We're not fulfilling our mission. And so a great deal of the $1.2 billion worth of work that you're about to see was really intended to turn Lincoln Center inside out. Our architect, Liz Diller, calls it an architectural striptease, because what you're seeing is the stripping out of travertine, the replacing it with glass, the reflection of what's going on inside our stages in digital media outside the concert halls and right out on the street. And so how do we as lawyers effectuate those grand and lofty and worthwhile principles through agreements and through drafting and through legal decisions? That's where we're going today. Just to situate you, this is where Lincoln Center is on the Upper West Side of Manhattan. It's a super block between 62nd Street and 66th Street. It takes up 16.3 acres and a patchwork of ownership between Lincoln Center, Inc. and the City of New York. And this is what the corner of 66th Street and Broadway looked like before we started our redevelopment. Alice Tully Hall was a perfectly nice mid-century looking building, except it was rather nondescript. You would never know walking past it that there was an arts facility inside, that world-class chamber music was being played inside there by the Chamber Music Society of Lincoln Center, and that the Juilliard students were performing and rehearsing right in that facility. And so what our architect had the idea of doing was to press the arts out into the street and to change both the look of the building and its accessibility. And the next slide. That's not a rendering, that's what that same corner actually looks like today. So you can see she ripped off the front face of that kind of Soviet squat, squared off looking building, and she lifted it like the prow of a boat, and she wrapped it in glass rather than travertine. She lit it in a much more effective way, and you can walk inside that glassed-in atrium area, and you don't have to have a ticket. And you don't even have to know anything about the arts. It's so much more inviting. It draws you in. Again, it makes the arts part of the fabric of the community. This is the view down 65th Street, and you can see there's a rather heavy pedestrian footbridge there, also named Milstein. That pedestrian plaza was 188 feet wide, and you can see that it really darkened the streetscape. And so you would walk down that block and feel like you're taking your life into your hands. Not only that, but there were 4.5 lanes there, 4 lanes plus a turning lane, and so people would just go tearing down 65th Street, and if you're a pedestrian, that's really not a safe place for you. And so what our architect decided to do there was to replace that 188-foot span with a tiny little light glass footbridge. And it's exactly wide enough for 2 wheelchairs to pass each other and not 1 inch wider. So the whole streetscape has really brightened up. The sunlight comes in now. You can walk down the street. We've lowered the street level identity of the Juilliard School, the Film Society, the New York Public Library for the Performing Arts, and all the other facilities that live along 65th Street down to eye level so that you know what you're seeing and you can take part in it. And that's what it looked like under the aforesaid footbridge. That was the street level entrance to the Juilliard School, right? You've got these kids who are going to the Harvard Law School of conservatories, and yet this is not a particularly grand entrance. And that's what it looks like today. We've taken out the bridge. We've brought the street level entrance up to a second level, so it's got a lot more grandeur to it. And again, the glass. Those kids put on 600 free concerts a year. They practice like crazy to put on these amazing performances. And do you know who knew about those concerts and how to get hold of those free tickets? A couple of very well-informed, wealthy people from Park Avenue, which is exactly not what we're trying to go for when you're talking about access to the arts. So we put the box office behind glass right there so that you could wander down the street. We've got 2 large public high schools. We've got a gigantic housing project right at Lincoln Center. And when people are walking down that street, now they know what's going on at the Juilliard School and how to pick up those free tickets. That's a view across the North Plaza, the before version. The style of architecture that was in vogue in the 50s when this was being originally planned was called brutalism. And the architecture was intended to reflect the brutality of life in mid-century America and the Cold War and that we just come through, yeah. So yes, it's brutalist, you know, I can't argue with that. It's not very beautiful, it's not very inviting. There's not too many sprigs of grass there, for example. There is a very nice reflecting pool with a Henry Moore sculpture in the middle of it, but there's absolutely nothing inviting about that scene. And that's what it looks like today. So we put in a restaurant with a rolling grass roof lawn on top of it on the left side of the picture. In fact, that's the cover image that I picked for my book that I wrote about the legal needs of nonprofits, because there's a story about that that I won't get into now, about the people on the board who were worried that this sloping grass roof lawn was going to become like a personal injury hazard. It's not, never had an incident there. And you can see on the right side of the picture that there's a tree arbor that people can take out books from the public library for the performing arts and sit under the trees and read, go to free outdoor concerts, and not have the sun blaring down on them in the summertime. And this was the entry sequence at the Columbus Avenue side, the main entrance. And you're kind of taking your life into your hands if you're crossing over to Lincoln Center from the far side of Columbus Avenue. You're crossing over 11 lanes of traffic. Then you get to Lincoln Center's portal, and you go up the stairs, and there's 2 more lanes of traffic. You've got this taxi drop-off that interrupts the flow between the Fountain Plaza and the street. And so our architect had the idea of depressing that drop-off down to the concourse level so that it matches up with the subway and it matches up with the tunnel system, and have an uninterrupted flow from the community to Lincoln Center and back again. And that's what that looks like. And so this is kind of to sum up this piece of it, the Lincoln Center as originally constructed. It was an amazing idea for its time. It was the first time that different genres of the performing arts were all pulled together under one roof. It's, from an economic model point of view, it's a gigantic nonprofit co-op. Lincoln Center owns the buildings, but nobody pays us rent. So the Metropolitan Opera, the Philharmonic, the Juilliard School, the Film Society, and everybody else that lives there contribute on a share and share-alike formula to the actual operating expenses of being there, so that nobody has to worry that an evil landlord is going to either hike up their rent, making the arts unaffordable, or knock down the building and put up a commercial high-rise instead. So great idea. The execution of it was maybe a little bit kind of landlocked in its time, and so we tried to keep what was good and bring everything more into line with our current expectations and mission. So how'd we get there legally, Peter?
Okay. So once upon a time, Lincoln Center for the Performing Arts, Inc., which is the umbrella organization that Lesley described, as opposed to Lincoln Center, which refers to the campus, had the idea to create this. And they had a master plan architect who came up with the original ideas, and they had a budget which was $1.2 billion. Now, I'll go to the next slide. These are arts organizations. So suppose you are counsel to LCPA, and your client says, okay, I have this wonderful idea, and I've got a huge amount of money I have to raise. How am I going to do this? How am I going to organize a family, and sometimes families are a bit dysfunctional, to come together to execute this amazing project? Now, if you look at the list of the constituents, each of those constituents is a not-for-profit 501c3 organization which has a blue-chip board of directors of its own and has its own financial resources, financial limitations, and programming. Each one of those institutions is preeminent in its field. Now, in order to create this project, are you going to have each one of those organizations sign contracts? Are you going to have Lincoln Center sign all the contracts? How are the organizations going to contribute? How are the funds and the benefits going to be allocated? Well, that was the task. And what we created was something called Lincoln Center Development Project, Inc., which itself was a 501c3 organization. And on the board consisted of the chair of each of the constituent organizations. So this was a way of bringing everyone together in a project entity which could sign all the contracts, be a repository of all the funds, in the initial instance take on all the liabilities, and administer this project. Now, when you see those buildings, administering a major construction project is a bit like a military campaign. If you see the time schedules that the contractors put together, they are literally day by day and hour by hour. Every day, every hour is accounted for because it is a massive project, and these institutions had to be operating while all of this was going on. So that was the initial task, and that was the initial legal solution. Let's go to the next slide. Now, there were a number, obviously, of agreements. I mentioned dozens. This is just a sampling, and we're going to talk about three in particular. One was the Master Plan Architect Agreement, which was an agreement with an architect, the predecessor of Diller and Scofidio, to come up with the concepts and to come up with the budgets and the estimates, which basically was a way of bringing all the constituents together because, again, this was not something that everybody would just said, okay, I volunteer. It was an enormous undertaking, and it had many ramifications for each of these institutions. There were constituent bilateral agreements, which, in fact, why don't you talk about those? Because those were, I think, a key part of this exercise.
Sure. So as Peter said, each of the components of Lincoln Center is its own freestanding 501c3 organization. Our board alone has 75 members. If you take all the boards together, there's 455 people. I don't know how you govern under those circumstances. Some of the constituents were kind of along for the ride. They appreciated the work that was being done in the common areas, but some of the constituents actually had projects of their own that they wanted to pursue inside their facilities, which were aging. The Juilliard School, for example, did a 30% expansion of their facilities when they moved from just classical music, and now they have a jazz department and a dance department and a theater department and so forth. And so Lincoln Center created individual agreements between ourselves and each of those organizations to provide for the good coordination of their project work with the overall project work so that our architects don't step on each other, that our construction trailers aren't situated on top of each other and so forth.
We're going to talk in a minute about funding agreements, construction documents. Construction contracts for this kind of a project are very complicated. They have a variety of issues that have to be sorted out because a construction contract is different from other contracts in that it is a process. It's an attempt to capture in a document a project that moves in time. And So when you think about the scale of this and all the projects that had to be completed, it was a very interesting exercise. And there were also insurance issues. How do you insure for construction issues? And also we'll talk about an interesting insurance issue that came up with the city later on. And lastly, we'll talk about how we unwind the organization that was created for this project.
I'll just talk about insurance for 1 second. One of the very unpleasant duties that a lawyer has is envisioning the place blowing up. And you pretty much do that once a week, every time you're revisiting that you're entering the next phase of construction or that the insurance arrangements are rolling over for the year and so forth. And you have to imagine what's the worst thing that could happen. A crane falls on people from 65th Street. We had a lot of crane problems, not on our site, but in other sites in New York City at the same time. And so all eyes were on our crane. Is that one going to fall too? Part of your job, and maybe some of you like torts class, I remember people kind of tittering when you would hear about these crazy, situations that would happen and somebody got run over by a train, and some people think that's really funny, and I don't know, but it's an odd part of the job to have to envision these terrible things happening and then put arrangements in place, not only to make sure that you've got the best and most safe construction people working on the job, but also that you've got adequate insurance so that those calamities don't become calamitous for the institution's bottom line and its survival
and
as
by
well.
the way, during the initial stages of this project, September 11th happened. So then we had to think about what if there was another event which could impact this project, and what do we do now? So those are not simply academic questions that you talk about in a classroom.
And then, as with many type of business deals, we needed an exit strategy. So as Peter explained, we set up this freestanding entity, Lincoln Center Development Project, Inc., to hold all these construction projects and to provide a governance structure for all of these 11 organizations to cooperate. But how is LCDP going to end? Does it need to be of perpetual duration? It certainly can be under New York state law, but what's it going to be good for in the end? So that was an interesting project that we got to tackle when it was all over.
This is yours.
All right. So why did I hire Peter? I didn't actually hire Peter, and I almost actually fired him once, but that was before I got to know him. So I inherited Peter. I arrived at Lincoln Center in January of 2005, before the first shovel hit the ground. Peter had been involved with Lincoln Center for 20 years, even before that. So probably in excess of 30 at this point. I was really interested to understand the different relationships between the General Counsel and all the different specialized outside counsel. Peter, as you can hear, brings a real depth of expertise about large, complex construction projects and real estate arrangements. He also knows everybody who's anybody within the city of New York, the Planning Commission, the Buildings Department, the Law Department, people that we really needed to have on our side in order to get the funds flowing, in order to get the permits worked out, in order to get the zoning done correctly. So really the special expertise that Peter brings is, I would say, the top criteria that he brought to the table. I will then really go on to talk about kind of the personal relationship that develops between in-house counsel and outside. There needs to be a real trust there, and it's a trust that goes both ways. Because Peter is not walking the halls of the organization knowing what's going on, what the changing plans are, the changing focus, the changing budgetary picture, the changing personnel. That's me. I'm out and about in those halls every day. I don't just sit in my office and hope that legal matters will walk in my door. I really need to make an effort to get out there and understand the whole context of the organization. And I have to be counted on to feed that information about the organization timely and accurately to Peter so that he can think about what adjustments may need to be made to these various complex funding agreements. And at the same time, I need to be able to trust him. I feel like our job as lawyers in general is to find a responsible way to make the answer be yes to whatever the question is that our bosses are asking, whether the boss is the chief executive officer, the board of directors. Our job is not to overrule them and say, oh, but you can't do that because section 302 of the code says. No. We need to find a way to make that happen. It needs to be responsible. We need to exercise our independent ethical judgment as attorneys and make sure that it complies with the law. But I can count maybe on the fingers of one hand the number of times that I've had to literally throw myself in front of a project or a plan or an initiative and say, there's just no way that you can do that. It is flatly illegal. You really need to scrap this initiative. No, the 99.9% of the time, there is a way to do it. Maybe there's 5 ways to do it. It wasn't the way that they were originally thinking, but that's the creativity. That's the fun part of lawyering. And what I need in outside counsel is somebody who's going to go with me on that stuff, who's going to not say, cite me the chapter and verse. I know the chapter and verse. I've identified the issue. I've spotted it. What I need from you is to brainstorm these 5 ideas so that we can get the CEO or the board chair where they want to go.
And that point is incredibly important. You, as a lawyer, you have to know your client and your client's business. And as Lesley said, a client does not want to know on the one hand or on the other hand. They want to know yes or no, and in fact, they only want one answer, which is yes. And one of the exciting things of working with a client as smart and as challenging as Lesley is that she always pushes counsel to find the right answer. And if you think about it, there usually is an answer. I mean, what I tell our associates and summer associates in the beginning is that there are only 3 answers to a legal question. Yes, if it's clear, there's a high court ruling, or there's a definitive administrative interpretation, or no, which is the same thing, or unclear. But if it's unclear or no, your client doesn't want to hear that. So your task, and this is where Harvard lawyers tend to be pretty good, is to see if you can figure out a different way of accomplishing the same result that's legal and ethical and works, and it's something that you yourself would bet the farm on. So that's a different way of saying it, but your clients want to know, they want an answer from you, they don't want an academic discussion.
My office is next door to the president's office at Lincoln Center. He wanders in my office all the time with harebrained schemes. I mean, there's really no other way to call it. And it so happens that they're usually genius and he's usually right. But we do need to figure out how to implement that, and it's not always obvious. That's really the fun, creative part of our jobs. But you need somebody.
By the way, I would say the same thing about what Lesley asked us to do.
The evil genius. But we need somebody with his doctrinal feet planted firmly in the earth of real estate law, construction law, zoning law, insurance law, whatever it is, but who can also help me brainstorm these creative solutions so that the president will come back to my office the next time and pitch me his next idea instead of just going off and doing it on his own because he's tired of hearing no from the general counsel.
So we're going to talk about 3 different agreements that were part of the redevelopment project. How many of you have taken a class in zoning or land use or had a property class where you talked about zoning or land use issues? Well, let's go to the next slide just for a second. This is a map of the Lincoln Center campus. As a part of the redevelopment, you see the street that bisects the northern part of the campus, that is 65th Street. Now, Lesley showed you a picture of the Millstein Bridge that had to be taken down. There is now a new bridge that crosses the street. Also, in connection with the project, there were a number of street reconfigurations, and the city had to grant easements to Lincoln Center, including, for example, for the new restaurant, and Lincoln Center had to grant easements back to the city. So that involved a very complicated zoning exercise. Let's go back to the slide before, which resulted in what we call a mapping agreement. Now the purpose seems straightforward: to confirm the city land use actions, extinguishing easements, granting easements, and agreeing on design controls and maintenance and operation requirements. Now, why, if you're just dealing with literally feet or inches in terms of easements and bridge abutments and things like that, would you have to be involved with a complex agreement? Part of it is because of city land use procedures, which require, in essence, a process going through community boards, the city planning commission, and the city council whenever the city disposes of land. But also, here, the city is about to give Lincoln Center $240 billion. Million. No, I said million. And they wanted to have a say in what the campus was going to look like, and also in terms of future actions on the campus, down to the level of signage and illuminated signage. And that resulted in something called design controls, which were something much more than you would ever expect if you were simply doing a little agreement about encroachments, about easements. In fact, one of the issues in this was a 5-inch encroachment on the Juilliard School that dated back to 1970.
Yeah, right there.
And that was rectified by this agreement. I mean, 5 inches? So.
Actually, the solution to that was found by a first-year associate at Peter's law firm. She had done an internship with Lincoln Center Legal, so she knew us very well. And she discovered through some research that there's like some adverse possession type of right that you get to do if it's less than 6 inches. But in order to perfect that, you have to have sent a letter to some, city agency down in the basement somewhere within X number of months or years after the building got completed back in 1969 to claim your adverse possessory right. And she sent me not only the statute, but she sent me what the letter would look like so that I could have our archivist look for something in particular and not just, might there be a letter somewhere in the bowels of our archives that claims the right to whatever. So she sent me the form letter. I sent it to the archivist. Literally an hour later, this letter from 1973, which was within the statutory period, floated up to my office. And so the 5 inches was.
See, sometimes it's also good to be lucky. Let's go back to the prior slide for 1 minute. So there was also a question about how you valued the interest that the city was giving up, because the city has to be compensated for the fair value of their easements. And the city started with a number that was way up here, but by explaining and sort of microanalyzing the transaction, we got down to a number that was in the low 5 digits. So those are just a sampling of kind of the issues that were involved in this kind of an agreement.
And just getting back to those relationship points I made earlier, Peter was able to negotiate those more favorable terms because he knows the people inside city government. He knows who's going to be responsive to the arguments about making the arts more accessible and that this is an improvement for the city and it's going to help the city serve its populace. And that, to me, coming in brand new, both to in-house life and to Lincoln Center, that's not anything that I ever could have replicated on my own.
But I have to say that in order to do that, you have to have the law on your side and you have to marshal the facts. And when you do memos, you think that getting the legal principles are the most important, but getting the facts right is incredibly important. And you can have a statement of facts, which I always say there are 25 different ways of saying the same thing, but there's one right way for the particular occasion. So simply expressing clearly what the facts are in a short and concise way can win the day because the facts speak for themselves. Anyway, let's keep going. So we have the map down. Now we get to the money. The city of New York is giving $240 million for this project. And the city of New York doesn't simply just write a check to Lincoln Center for $240 million.
In fact, I like to say there's one string attached for each one of the $240 million that they're giving us.
So we had, when the city, first of all, I must say that the city, and this was under both the Giuliani and the Bloomberg administrations, has been a pioneer in making capital grants to arts organizations and to museums because they saw the enormous economic generator that arts organizations contribute. I mean, you have all the figures in terms of the enormous value that Lincoln Center brings to New York City.
$3.4 billion in economic impact each year from both direct wages paid as well as indirect lifting impacts on restaurants, retail, condo, and residential home values in the area.
So again, you're counsel for Lincoln Center, and you have to figure out how you're going to do, how are you going to move along the funding? Well, basically, we started small. The first funding agreement was $8 million, and it was for the demolition of the old Millstream Bridge and the construction of the new bridge. But that funding agreement was enormously important because it was the precedent for everything that was to come. Now, what do we have to consider? Well, this is $8 billion. The city is putting in, $8 million. I keep saying billion, okay. The city
I like how you think.
The city is putting in $240 million. Of that $8 million, when they put it in, how does that relate to the private funding that's coming from the Lincoln Center organizations, which is $1 billion? So does it go in what is called pari passu? In other words, does that mean that the city would put in 25 cents for every 75 cents that the Lincoln Center put in? We didn't want to do that because that was too constraining. And what we worked out was a formula under which Lincoln Center's match had to be 75%, but on a rolling basis and on a projected basis, so that we were able to use city funding in the somewhat disproportionately in the beginning, while the rest of the money came in. And the rest of the money came in various ways. It came in through contributions, it came in through bond issues, it came in through a lot of different pots, all of which flowed into Lincoln Center development. So that was an enormous part of the negotiation of the first funding agreement. Second issue, you're the city. Okay, we've created this neat corporation which has on the boards the chairs of all these preeminent arts organizations, but does it have any money? And you, the city, have a rule that if you fund a project, you have to know that it's going to be completed. So you're about to sign funding agreements with an entity that's been set up to, for a lot of good reasons, but doesn't have any money. And what do you need as security? Well, that resulted in a guarantee by LCPA, which was itself extensively negotiated, which enabled the project to go forward and was backed up by those interconstituent agreements that Lesley was talking about.
So we get the full faith and credit of all the resident organizations' assets backing up the rather thinly capitalized development entity.
One last point I'll make, and that is when the city or other municipal governments make capital grants, typically they have to follow the rules of tax-exempt bond counsel, the bond requirements. And some of those rules require what are called capital eligibility. And that means that a dollar that's spent has to be capitally eligible. Well, since I know most of you have taken accounting, you know what a capital asset is. But a capital asset doesn't have to be something that's just bricks and mortar. Soft costs, architect's fees, legal fees, other insurance premiums are soft costs, but they are capital assets because they have a life longer than 1 year. So, but each monthly requisition by the Lincoln Center development to the city for funding had to demonstrate that all the costs were capitally eligible. Let's go to the next one. So we have the mapping agreement, we have the project entity, we got the money flowing in, and in the midst of this, something else occurred, which was the scheduled expiration of Lincoln Center's license agreement with the city for the plazas. The plaza areas are, I think if you remember the pictures in the map, There are plazas when you enter Lincoln Center, and on the north part, and you also have Damrosch Park, which is a city park. Now the city owns those areas, the public areas. LCPA owns the buildings. And from the beginning of from the creation of Lincoln Center, the city has licensed or agreed with Lincoln Center that Lincoln Center would essentially act as a manager of the plaza areas. So the license agreement was due to expire in 2007. I think it was 2006, and we carried over a year. So it took us 2 years to negotiate an extension. 3.5? See, time flies when you're having fun. It took a while to negotiate the extension of the license. Why? You say, well, if Lincoln Center is simply a manager, does a manager have capital repair obligations? What happens in the event of a major fire? Who's responsible for torts that happen? Under the old agreement, Lincoln Center was not responsible for personal injuries that occurred in the public areas. Now, why is that a concern? Because there are quite a few slip and fall cases, or there have been, in the public areas, and the city always indemnified Lincoln Center for that purpose. This time around, they said they didn't want to do that. So that entailed a lengthy negotiation about the allocation of risk and liability for those kinds of problems. It also involved a lengthy negotiation about structural repair obligations, because Lincoln Center was not about to undertake a 20-year agreement to do any structural repairs on the plaza. The plaza is essentially the roof over a garage and a mechanical plant. And that would have been like writing a blank check. At the same time, the city was not going to write a blank check, because the city has its own budgetary constraints. And interestingly enough, the city, like many other cities, can only appropriate money on an annual basis. So it's difficult for the city, except in extremely unusual circumstances, to obligate itself contractually beyond 1 year. So the result was a negotiated resolution that addressed all these problems, and I think came out in the right place. And lastly is something that I know is dear to Lesley's heart that I'm going to ask her to talk about, which are the concessions in the public areas.
Oh boy. There's a lot of public policy issues involved when a private not-for-profit corporation is administering public lands on behalf of the city. And so we ended up with some really interesting questions about whose right is it to let out concessions, whose job is it to schedule events in those public areas, who gets to keep the money, what do we have to use the money for? And we had extensive conversations with the city of New York on each of those topics. They were binding themselves for 10 years, which was going to take them past the then current administration, and we were binding ourselves to make sure that we were coming up with an economic model that was going to be sustainable for Lincoln Center, that was going to allow us to continue to do these great free outdoor programming, and at the same time keep the public safe. We have 5 million visitors a year. We don't want them tripping and falling. We want to make sure we have good security, good lighting, adequate paving maintenance, and snow shoveling and removal and so forth. So just a whole lot of really interesting policy and economic issues that fed into this legal agreement.
So now we come to the almost end of the story. We talked about the issues in creating LCDP. So now we're at the end of the project, and if you're counsel for Lincoln Center, what do you advise in terms of unwinding the project? So Lesley came to us and she said, give me all the pluses and minuses and let's come up with a game plan. And interestingly enough, one of our associates, Ashley Dunn, who is now a 5th year, but who was a Harvard summer at that time, did a lot of the work on that project. And what the issues that we had to deal with were, first of all, how do you close out all these construction contracts? Closing out construction contracts is almost as complicated as setting them up, because at the end of a large project, there are numerous sign-offs and permits that have to be obtained. There are usually, well, unfortunately, usually claims that have to be resolved. There are warranty obligations. There are payment issues that have to be taken care of. There are a variety of tasks that all have to be wrapped up. So that had to be dealt with. So we still needed to keep LCDP for that purpose. Also, we had to ask, if you close down a corporation, what happens? What's left? Hopefully you have identified your known liabilities and you know what your current assets are. And hopefully you know what your claims are and what your pending assets are. But typically you don't know what your contingent or unknown liabilities are. So that means you have to look at the different statutes of limitation for these types of things and decide, do you really want to close down the company and dissolve it? And what happens if you dissolve a company? What happens if liabilities come in after the facts and you have a dissolved company? Well, the decision was made to keep LCDP, but at the same time, it no longer needed the blue ribbon board. And as Lesley is going to talk about in a second, there was a future for it, which evolved. But the structure that we developed was simply to have all the other constituents resign as members. So what that meant was that we wound up with a single member, LCPA, and so that this is now a wholly owned subsidiary of LCPA. Now, you want to talk about the bright future?
Sure. So then everything was proceeded apace. It was a very orderly wind down. We had very few either personal injury claims or claims by contractors. And we had this entity that still existed to house those last remaining tail obligations. At the same moment, Lincoln Center realized that we had developed all this expertise about how to plan and construct and build and operate and manage and program these spanking new arts facilities. And this was knowledge and know-how that other people in the world might be interested in. Maybe they would want to hire us as their consultants, maybe cultural and educational consultants, to teach them how to either renovate their facilities or maybe plan them afresh. And so one of our board members had the idea to form Lincoln Center Global, a global consulting company. And my next job after redevelopment was to figure out where to house the consulting company. Should we just embed it within the structure of the organization? Does that create risk or liability to our bottom line that we have not really figured out how to provide for? Where should we house this new consulting project from a legal perspective? And one of the ideas that we came up with was to convert LCDP, since it still existed, into the holding company for the contracts for our global consulting, so that we would have a place of limited liability, a place to remove it from the balance sheet of the main organization, a place to look to for the employment of these people, for the contracting of our new clients and so forth. And so we turned once again to Venable. By that point, Peter had left the firm that he had been with all those years, and I had a little something to do with that, but anyway, it's a different story.
It was a firm that you may have heard of called Dewey and LaBeouf.
I had introduced...
It was not a voluntary departure.
Introduced Peter to some wonderful friends of mine in a highly regarded not-for-profit legal practice at the law firm of Venable, and they decided that was a great fit. And so he went to this firm, and that firm ended up providing us with the legal backup to convert the purpose, or expand, I should say, the purpose of this Lincoln Center Development Project entity into this holding company for our global consulting contracts. I'll just say a quick word about this, and I want to make sure there's a minute for you guys to ask questions. I'm known as the Queen of Pro Bono. It's like being a welfare queen, except it's like in a legal department. And that is to say that I shamelessly hit up my friends for pro bono legal work, and they are very gracious to accept. We have 25 major New York law firms doing pro bono projects for Lincoln Center. And yet there are some that are doing paid outside work. And so how do you square all that up? How do you look one in the eye and say, you do it for free, but I'm paying his rates? Sometimes the answer is, well, we got to stop paying your rates. Sometimes the answer is, would you switch over and become pro bono? That's kind of an awkward conversation. Peter was very forthcoming in helping us define some projects that we could work on together that fit within his firm's pro bono institutionalized program that were beneficial to the arts, to the cultural community, to our educational, and at the same time we retain a regular billable arrangement for the other traditional work that he's been carrying out for us and continuation.
I also would say that Lesley has been transformative as a general counsel in the not-for-profit world, because in my experience, nobody has ever achieved what she has in terms of bringing law firms on a major scale, and the best law firms in town to do major work contributing at pro bono. I mean, and frankly, I've been surprised that not too many other people have followed that model. But it's somewhat hard to follow her model in any event, because she is a trendsetter, and not that many people can keep up with her. But she's been transformative.
Thank you. Chapter 13 of my book and an article will tell all if you are involved in an organization that needs to hit up people for pro bono work. I think that's it. Is there a minute or two for questions?
Somebody want to come up? And who's boss? What do you think?
She's the boss. Let's say.
Wow, you've been doing your homework. So yeah, part of our land is deeded as parkland, so there has been a controversy. In fact, there's a current litigation going on about whether or not we could license or sublicense that parkland for other uses, for example, New York Fashion Week. We use it for other purposes too. We have galas there in the springtime to raise money for the arts. And during the summertime, we use it for free outdoor programming. In the dead of winter, we have the Big Apple Circus there. So there's really interesting, I think it's a very dynamic area of the law right now, which of those uses would fit within the public trust doctrine, and what's a temporary or de minimis use that would allow you to make a non-park use of deeded parkland. How long is temporary and how much is de minimis?
Before